Milling Through History presents the Supreme Court. A great deal can be said about the Supreme Court right now, as many people are suddenly becoming experts on the judicial branch of the government. There are many who think they know exactly what it's supposed to be and how it's supposed to work, and yet, for all the people that claim they do know, the reality is their research is usually very minimal. As such, in today's episode, we are going to examine the Supreme Court and specifically how it is that judges come to the bench and, in a small respect, what it is that they actually do. So, what exactly is the Supreme Court? Well, it is the highest court in the land, and the court itself holds the power of judicial review, which means this is the ability to invalidate a statute for violating a provision of the Constitution. In addition, the Supreme Court has the ability to strike down any presidential directives for violating the Constitution or statutory laws. However, the most unique part about the Supreme Court's powers, though, is that it can only act within the context of a case where the law has jurisdiction for the Supreme Court. We'll get into that a little bit more later. But perhaps one of the most unique facets that's been coming out about the Supreme Court is, why is it that we're stuck with 9 justices? Couldn't we just add more or take a few away? Well, the Constitution does not define exactly how many judges there are supposed to be. Rather, it instead refers to the court having federal power vested into one Supreme Court, with inferior courts being created by Congress. Now, the vague terminology from the Constitution would lead to the Judiciary Act of 1789, which would establish the creation of the Chief Justice to the Supreme Court, along with 5 associate justices. Each of the justices would ride a circuit wherein they would be hearing cases for appellate courts. Now, the Supreme Court itself would expand its size 3 times, those being the years of 1807, 1837, and 1863. In 1869, however, the Circuit Judges Act would set the number of justices in the court to 9, where it has remained ever since. Now, with it being set to 9, there have been an attempt to go ahead to create more Supreme Court justices in order to ensure that the rulings of the court goes in one particular person's point of view their way. This particular circumstance would occur during the presidency of Franklin Delano Roosevelt. What he had come up with was a plan that he could go ahead and pack the Supreme Court with judges who were friendly to the New Deal. As such, when Roosevelt came up with this plan, he was immediately met with a great deal of backlash, not only from politicians on both the Democrat and Republican side of the aisle, but also from citizens of the United States, who felt that this was his attempt to go ahead and ensure that you were creating effectively a type of almost dictatorship-like regime where the president could ensure that whatever law he wanted to create, the judges were sympathetic to it. Ironically enough, though, while Franklin Roosevelt was unable to pack the court by adding in more justices, he was able to change the face of the court, as 8 of the 9 justices who started during his first year of the presidency would either die or pass away. As such, he would be filling 8 vacancies, and this would allow him to permanently shift the views of the court from being more conservative center of the line to being liberal. As a result, this would go ahead and be seen as only being achieved due to the fact that he was in office for 12 years. In the modern sense of the Supreme Court, though, there are a number of people who consider the prospect of a shifting court from being too conservative, too liberal, being very dangerous, and the selection process for choosing a person to sit on the Supreme Court has come under greater scrutiny. For instance, the President of the United States has the power to nominate a person to the court, but it is the Senate which will confirm the appointment. Once the President has gone ahead and nominated their appointee, this person will first sit in front of the Senate Judicial Committee, who will interview the appointee and decide to give a positive, negative, or neutral report, and thus indicate to the Senate as a whole whether or not they decide that this person is qualified for the job. Now, ironically enough, there's actually nothing in the rules which says a person with the result of negative or neutral cannot go ahead and have their name put forward to the full Senate for a vote. Although, not having a positive outlook does sometimes indicate your nomination might not be lasting very long. Now, nominations can be blocked by filibuster. However, that option was eliminated in 2017 by Senator Mitch McConnell. The Senate can always have the nomination removed if the candidate does not have the votes. For instance, if it's clear that they do not have a majority, that means the candidate will go through. As such, the president, in order to save face from potentially being put in a position where they are embarrassed by not having their candidate pass, will go ahead and pull the nomination and look for another person. Now, interestingly enough, a third attempt to go ahead and effectively end a nomination process is one that is rather unique. Namely, the Senate could always try to run out the clock on their session and effectively end the nomination once they go into a recess. Now, prior to 1981, the confirmation process took around 1 month to complete. As such, the bench would rarely ever find itself without its full 9 members. However, since the Reagan administration, the process of going ahead, nominating, going through committee, and getting a vote on a Supreme Court justice has dramatically increased, be anywhere between 67 and 71 days. The reason for this is quite simple. The Supreme Court has become a new political battleground as people look at the justices, and if they see that there are 4 liberal and 4 conservative, then there should at least be 1 independent. However, as the court shifts back and forth between conservative and liberal, undeniably there will be periods of time where we will see dramatic shifts in the way in which the court rules on different topics. As a result, while most people wish that the Supreme Court could remain completely independent of politics, and therefore their word would certainly be valid, others point out that the Supreme Court as a whole is rather moot, as, to quote Andrew Jackson, they've made their decision. Now let's see them enforce it. As such, could you argue the Supreme Court is nothing but a toothless tiger? There is certainly a case to be said that the answer is yes. For more information, please consider these suggested titles. Be sure to click on the left-hand side of the screen to subscribe to our show, and on the right-hand side for our latest episode. And we will see you again for the next episode of Milling Through History.